attempts to thread a needle by just using a wrecking ball. How are you going to prove $10,000 worth of damages? And in most cases, your damages are going to be impacted by mitigating factors. Did you do everything you could to limit those damages? They preserve some of the very limited private rights of action that are contained in the CCPA and the BIPA that do not exist in this proposed legislation. It preempts way more than just basic privacy laws. It preempts anything that seeks to address data collection and use.
Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, we're back. So an updated version of the proposed American Privacy Rights Act, which we touched on lightly with Amy Worley a few weeks ago, was published on the 21st of May, so last week, ahead of a review, or markup as they call it, in the US House last Thursday. Now, the use of personal data in digital advertising, or rather the instances in which this would be allowed, was clarified, besides many other things like dealing with data brokers or protecting children. To review this initiative, so again the American Privacy Rights Act in depth, and crucially its interplay with state-specific privacy laws, we're lucky to have Brian Focht here today. Brian is a cybersecurity and data privacy attorney practicing in Charlotte, North Carolina. He helps customers of all sizes, including large global companies, on cybersecurity and data privacy issues, including litigation, data breaches, internal policies, and beyond. He is a UNC Chapel Hill graduate and holds both an AI governance and CIPP US certificate from the IAPP. Our guest is also the founder and co-host of the Fearless Paranoia podcast, making cybersecurity more accessible to those not in the IT, cybersecurity, or data privacy industries. Let's get on with it. Brian, thanks for joining me.
Glad to be here.
Okay, so what do we do with this, with the American Privacy Rights Act? Why do you think it's not going to happen?
Well, I should, right from the start, I should say, I think that this effort to put together this particular version of a national privacy law was a significant effort and does cover what I would say probably 95% of what I would hope to see in a national privacy law. It leaves something to be desired, especially for more individual consumer level privacy advocates like myself, but it does actually do a lot of things, a lot of good things that things like the GDPR and CCPA have started. It is short in some areas, it actually exceeds in some areas. So I want to say right from the start that I do actually have a lot of respect for the bipartisan group of legislators who have tried to come up with this. I don't have a crystal ball into how this is going to get through, but in the past, there have been two kind of bellwether things in legislation where you could pretty much say you include them and you're going to exclude a certain political party from being involved at all. Those two things are preemption and private right of action. In a privacy law context, including preemption meant you weren't going to get any Democratic votes, because that meant that that Illinois' BIPA, that all of California's laws were going to be preempted by this state law. And it was, I think it pretty much went without saying that the federal law was going to protect less, or protect less aggressively, or protect in a less detail oriented fashion than these state level laws. And I think that's when you compare this proposed law with the laws currently on the books, that is what, in fact, would happen. This is not as broad or as detailed of protection as you find in CCPA. It excludes a lot of major things that CCPA does cover. One of the major ones is employee information. And the private right of action is, well, I'll just go straight on to that second component. The second component was the private right of action. You include a private right of action in, well, not everything, almost everything these days. And that means that you're not going to get any Republican votes. There are notably certain issues that the Republican Party is very willing to add a private right of action to, but usually that involves uh, uh, what I would describe as personal medical decisions, and I'm not going to get into any more on that topic. This particular law, I'm going to really mix metaphors here. Attempts to thread a needle by just using a wrecking ball. It's an interesting decision, and again, I don't have a crystal ball, so we'll see how well it works. But this particular law includes both preemption and a private right of action. Now, when I'm involved in negotiation, I don't typically myself, or when I advise my clients, suggest that including a poison pill for both parties as the preferred method. Usually you try to avoid any poison pills. It's almost, the attempt appears in this case to be to say, all right, there's something each of you hate. And there are little carve outs. So for example, the private right of action in this case is fairly limited. It's going to be it's restricted to what you personally experience as a loss. So for a lot of people or a lot of attorneys who are involved with personal injury cases or breach of contract cases, when you're assessing damages, this would be a damage calculation to be pretty familiar with. You're entitled to what you actually lose. Well, the difficult part with that for anyone who has done privacy or cybersecurity litigation is that those damages are very difficult to prove. And even when you prove them, they tend to not actually amount to all that much. So at what level here is the private right of action without an entire section for procedure for class action litigation, which is really the only remedy that allows for recovery for injuries with, I hate to say, small amounts of damages, because to an individual, a $10,000 fraud charge is potentially catastrophic. To a major business, that's not even a rounding error. That's way less than a rounding. So, I mean, you're talking about how do you classify what is a serious injury? And it's going to vary considerably. And what we are talking about here is we are literally talking about the smallest possible legal entity, the individual, as a consumer, versus the biggest possible legal entity, the biggest technology and data collection companies in the world.
Yeah, yeah.
With no special procedures or provisions against each other. So that's what makes that a little bit tricky.
So we're opening a sort of Pandora's box. I hadn't thought of that, of the fact that you've got all of these non-material damages. And what is a privacy harm, right? These days there's a debate. Again, we're opening up the debate as to the, for example, the Solovi taxonomy, right? It's been criticized by, I believe, Ryan Callow. And then he's replied, and we are sort of revisiting what's a privacy harm. In the EU, there's been 3 cases at the CJEU on this, on collective redress, or on what it is that you can claim as damages. And it's sort of taking shape. but it's so abstract, and we never had to deal with it. So do you think that would help finally understanding what's the protected element here?
Well, I think it is important as an attorney who has litigated a lot of cases where damages and the identification and the calculation of damages is important. I think it is important to include that in the law. And just so we're clear, I wanted to actually go straight to the proposed statute and identify substantial privacy harm. Now, that's the term that the law uses. It's any alleged financial harm of not less than $10,000 or any alleged physical or mental harm to an individual that involves one, treatment by a licensed, credentialed, or otherwise bona fide healthcare provider, or two, physical injury, highly offensive intrusion into privacy expectations of a reasonable individual under the circumstances, or discrimination. Okay, so what we're talking about here is one, so the first part, treatment by licensed, credentialed healthcare provider. Basically, that's your mental anguish. I mean, unless you're talking about, someone being driven to self-harm, uh, you know, going to a hospital, having, that the vast majority of damages under this particular calculation are going to be based on uh, psychological treatment, psychiatric treatment, any, mental health treatment. Now, what it doesn't say, um, and what you do see in a lot of what would be described as more tort reform based laws in the United States regarding damages for uh, mental health related injuries require a diagnosed condition. This does not. So, I mean, that leaves a more broad scope for any of the potential harm. The other is physical injury. I mean, I'm not even sure what physical injury you would identify, but
Yeah, yeah.
otherwise, not less than $10,000.
But they still make it quite objective, right? They still make it quite short term. I mean, so whenever we look at privacy harms, and we've tried to differentiate the idea that we have in Europe with data protection, the idea that it's not something you can feel today that is so close to confidentiality, right? That it's long term and there is a future freedom, whatever is going to happen one day that will come and bite you. Uh, and that's not here. We are sort of tying it to something you can measure in the very short term, right?
Yeah, and actually, that has a really close parallel to cybersecurity litigation in the United States, how that has progressed. I've, as a cybersecurity attorney, have been of the opinion that one of the things that's going to have to change is the way that we calculate damages in these types of cases, because the bottom line is you have no idea right now what information resulting from one data breach can do when combined with information, even information legally collected and obtained down the road. And this idea that, I mean, this is going to be the big problem with bringing a private right of action in this particular context, because the mental or physical harm question is, I think, going to be on its own. It's going to be a very small component of the damage claims, just because they'll be difficult to prove. But the dollars, $10,000, a minimum $10,000 personal, damage, given the status of credit card insurance, the status there, the availability of credit monitoring services, things like that. How are you going to prove $10,000 worth of damages? And in most cases, your damages are going to be impacted by mitigating factors. Did you do everything you could to limit those damages? And did those mitigating factors bring it below $10,000? Does that mean you are no longer able to bring a claim under this act? There are a lot of questions here. I don't think that this is fleshed out nearly enough. In fairness, this is the draft legislation. It has not been subject to markup or amendment, which, I mean, could easily destroy it. And the definition of injury is going to be very fluid, I think. in this area for a long time. So one could argue it may not even be in the best interests of people trying to ensure privacy by codifying it in such a narrow fashion. That said, codifying it ensures that it actually is used and considered by courts.
Yeah. So in a way, yeah, if you combine it with preemption, it seems to be favoring one political party or one point of view, if I understand that well, because in the end, this is a very hard to ascertain, right of action. And if you look at the Illinois, you were mentioning the biometric privacy law, there's been gigantic, settlements in there, or what people think is coming in in the state of Washington with My Health, My Data, right? So if this was going to preempt any cases under Illinois, I don't know, maybe it's not going to happen because it's health related or biometric. What do you think? What's the interplay?
So now I will say this. So this draft does have an interesting carve out in the preemption that was, I think, an attempt to win over Democratic votes in Congress from Illinois and California, obviously two very populous states with significant congressional representations. They preserve some of the very limited private rights of action that are contained in the CCPA and the BIPA that do not exist in this proposed legislation. I'm not sure. I don't practice in California. And while I have advised dozens of clients on compliance with CCPA, I have never been involved directly with litigation arising out of a private right of action for CCPA. So I'm not going to profess familiarity with what impact the carve out will have on California's rights. I do know that the Illinois carve out is particularly interesting in light of recent developments in the state of Illinois, both legislative and judicial. For anyone who's followed significant cases in Illinois regarding the collection of employee and personal data, biometric data, and the damages that have been assessed in some of those cases, the Illinois Supreme Court a couple years ago basically held that the most broad possible interpretation of the damages provision would be applied. But in that very decision, the court pretty much said, we think this is ridiculous that we're allowing damages of this amount. And basically, we're like shouting from the rooftops at the state legislature to fix it. It appears as though the state legislature has now taken steps to address and rein in some of those damages. And recent court cases in Illinois have also suggested that those damages are going to be somewhat reduced. The carve out for Illinois allows for claims for Illinois residents, it's only for Illinois residents. There's some interesting carve outs in that they preserve rights exclusively for residents of certain states. And it's not clear at this point whether the residency requirement is going to be frozen as of the date this gets enacted. So will you have to have been an Illinois resident prior to, I don't know, whatever, October 1, 2024? I would put money on yes. I would bet that the final legislation is going to put a time period on that, meaning that not only are these carve outs going to be limited to people who live in those states, but they're going to be date limited too, which means the value of the carve out is going to decrease over time. The major impact of the preemption is that all of the work that has been done by the committees in charge of enforcing the CPPA and CPRA are gone. That all of here's a big thing as an attorney who advises businesses on complying with cybersecurity and privacy laws. One of the things that I don't have at my disposal when I'm doing that consulting is consistent case law developed over time that establishes a baseline of what is reasonable. That's crucial in law. In the US, we are a common law system. We are based where we have laws that set the perimeter, and then the gray areas are defined by individual circumstances. You say, okay, what in if I do this and this and this, what impact does that have? Well, this court case has said doing this gets you X. This has said doing something slightly different gets you Y. And so you were able to sort of guide your response based on how similar previous or similarly situated businesses or individuals in the past have acted. We don't have that here. This is all too new. This is too new of a system of laws. This is for for American businesses. This is a brand new concern. Let's be perfectly honest. Unless you were involved in healthcare or finance, you didn't care about any of this stuff 5 years ago. That's a pretty big deal. With no court decisions before that, we have very little to go on. And the crazy thing in my mind is that BIPA, having passed in 2012, is actually the grandfather of all of these. It's the oldest one.
Yeah, I was thinking all of the large platforms are falling in there. Like you've got a Snapchat, a TikTok, a Meta, right? Everyone has
Right.
had to go through it and pay up.
Mm-hmm. And
Maybe that's the
and
guy. Yeah.
but that's sort of what's supposed to happen. And the good thing is, honestly, is that we do have these cases going through the system that are, tried to their conclusion, that are appealed, that have an appellate decision, that are appealed to state Supreme Courts, that have a state Supreme Court decision. You need to have these judicial decisions to provide guidance. Does this preemption wipe all of that out? Probably. Uh, so that's a big deal.
Okay. Do you see any other interplays on this particular matter? So state law, things that are coming up. I keep thinking of my health, my data, because I see a lot of people concerned. But do you see any other states where there may be friction when it comes to that preemption?
Now I do. The state of Vermont, the brand new privacy law that was passed there has a private right of action that is consider it's a more it has more breadth than the California private right of action does. Again, it's brand new. It is anytime I advise a business on new legislation, I always say that first of all, you're going to have the time to get ready for it, but then you also have to bear in mind that the first 12 months after any legislation is passed is kind of what I sort of refer to as the wet concrete phase. That's when legislation is most likely to be amended. And you will see, I mean, first of all, you're talking about passing laws in a national election year. So what does Congress do differently when the country is electing a president versus any other year? I do remember 2 years ago when the previous version of this federal law was proposed. It included a private right of action, but it included first a 2-year hiatus on the implementation, and then through amendment that got extended to 4 years. And all that told me was that the Republican Party was willing to vote, or was at least willing to accept the discussion of the private right of action as long as it was delayed for 4 years. And my assumption was because they presumed that at some point during those 4 years, they would have the House, the Senate, and the White House, or the House, the Senate, and a Democratic president who was willing to give away the private right of action in exchange for something else in legislative negotiations. I don't necessarily think that was a losing strategy. I think that they probably would have succeeded along those lines. And so I do wonder in any of these things, the first 12 months is going to tell you whether or not the Vermont private right of action survives in the form that it's in. Also going to see whether or not the courts do anything with it based on, I mean, you have to bear in mind any private right of action still has to comply with all the pre-existing procedural and substantive requirements for filing and dealing with a lawsuit in the jurisdiction that it's in. So we'll see how the courts there take a look at it and apply, their particular rules to it, and what form it really takes. Um, Now, other areas that I'm a little curious about whether or not this privacy interplay is going to have an issue is you have Utah and Colorado who have recently passed AI laws. Now, if you read this proposed federal privacy law and its preemption, it preempts way more than just basic privacy laws. It preempts anything that seeks to address data collection and use, data brokers, the classification of data as regular, sensitive, deserving of any extra confidential protection. I have legitimate questions whether or not some of the preemption provisions in the statute may have an impact on how state bar groups are allowed to designate confidential information. This preemption provision is incredibly broad because this is the first real attempt to regulate something that the federal government has never regulated and touches everything.
So things like the Delete Act, right, and things like that, those could be preempted.
Well, I think the Delete Act would be preempted. I think it absolutely would be. Which also means that the Texas Data Broker Act would also be preempted. And so it's not just blue states whose laws are being preempted here. Utah being the first state to pass an AI law, Texas being one of the first to pass a data broker law. This is going to upset hornets' nests in quite a few different states.
Well, I find it very interesting because now in Europe there's a debate between the UK, which is addressing AI from the GDPR, right? With the UK GDPR without need, clearly stating that there's no need for an AI Act in the UK because data protection principles cover AI. And we could have this debate internally in the US as well. In Latin America, they're having that debate. We had another interview last week on that. Latin American countries like Brazil coming up with AI-specific law versus others trying to address AI with the data protection, playbook. And then what do you think is the impact on the data privacy framework, or rather on the adequacy of the US if we were to have a Schrems 3 and data transfers are put into question again?
I think that the first 3 letters out of Schrems' mouth every time he appears in front of any court, NSA, is not impacted at all by any of this. And quite frankly, I think the expansion of authority under Section 230 that was recently passed in the 2-year extension just gives more ammunition. And I mean, I've always been a little bit skeptical about this notion that the real fear of the EU is the data being taken in by the NSA, just because there is espionage and counter-espionage activities being undertaken by any technologically, adept government all over the place. So I have some questions about that. However, I actually think that the most recent expansion of Section 230 authority may be the most legitimate basis to argue that the privacy shield is literally no longer creating any kind of actual shield. The bottom line is
privacy framework.
Yeah, I just think that the best argument, if we wanted to give an easier argument for why the framework should not be upheld, we just gave it to them. It is that to me is the most legitimate basis for knocking down the privacy framework. That being said, I gave a presentation to a data analytics graduate program course not long ago, and I was talking to the professor afterwards, and we were discussing a section where I said that one of the difficult things to understand about different privacy laws was that you really had to understand why and how they came about. And you also have to appreciate that they indicate how different societies think about different things. In Europe, in Europe, the citizens are looking for the government to protect their data against both large companies and outside governments. In the United States, our laws have always built on this notion that we are trying to protect individuals from the government. So it's a the values of the society are constructed into the laws. So this law is no different than that. This American Privacy Rights Act is one that still assumes that the real threat to the individual is the state. It finally gives some lip service to the notion that maybe these massive corporations shouldn't be able to freely, without oversight, regulation, or the need to comply with any basic system of decency, let alone regulatory structure, maybe they should be subject to some of these restrictions as well. But it's still, you know, it also assumes, I think, without any basis, that as long as your business has fewer than 150 people, you are doing the Lord's work. Exempting small businesses from basic protections of people's individual privacy is, in my mind, just mind-blowing, because there are so many ways to construct a company that makes it so you don't, so you can sneak under the radar. There's also a lot of weird ways that I think that we define de-identified data. I have a huge problem with the concept of de-identified data because it says, covered data is anything that cannot be reasonably linked to an individual, on its own or combined with other data. But it automatically exempts de-identified data, and de-identified data does not include information that is de-identified and cannot be reasonably re-identified when combined with other data.
There's a contradiction. In fact, the way we've been
So,
using the identify, that's not
yeah,
anonymous.
I mean, and the GDPR has put in some interesting, well, actually the EU AI Act discusses, pseudonymous data and anonymous data in a much more clean and clear fashion than any privacy law, even though it is a privacy system. Why? I don't understand that. So, I mean, there's a lot of ways I think that this law could be improved that would potentially give the administrators of the GDPR reasons to say, okay, it's gotten better. And I honestly think that that's what most of them are looking for. I think that I do think that as long as the federal government, the U.S. federal government and state governments and local governments are some of the biggest consumers of data brokers in the world. And in my opinion, data brokers are the one entity that needs to be most directly assessed by this. The GDPR protects data subjects. That's the center of the GDPR. The American Privacy Rights Act limits what companies that fit within their definition of a covered entity can do. Their approach is to say, as a company, you can't do this. The GDPR says protected data has to be protected. GDPR says you have to get, consumers have an opt-in. American Privacy Rights Act says it's an opt-out. That seems like semantics. It's not. It's a huge deal. So there's the cultural priorities are on display, and I'm pretty curious to see whether a law like this would impact the way the administrators of the GDPR see, and the courts see the adequacy and the protection. I do think that as long as the NSA is allowed to do whatever they want, Schrems is going to have a phenomenal argument for his position. But I will say, going back to one thing you mentioned earlier, the idea of regulating AI, between the difference between the EU and the UK. And I think it can really be broken down to is, should AI be regulated? And the EU says yes, and the UK says no. But in the UK, they say no while on stage with CEOs of every major AI company on earth. That's basically the difference. That's basically how they do it. I mean, I couldn't stop laughing every time I saw a video from the AI summit that they held there last year, where it was just basically Sunak on stage with whatever CEO he could find. It's like, not a data privacy advocate within a city block of the entire thing. But there's something to be said for enforcing the laws we have rather than creating new ones to take up space. And just in the US, I think it's way too common that we write and pass laws in order to look busy but do nothing. So there's absolutely something to be said for, hey, do the laws that currently exist on the books apply? The counter argument to that is, based on the way the laws are currently being enforced and based on the way these companies are currently operating, you need to have something. And right now, what we have on the books ain't doing the job.
Brian, very insightful. Thank you very much.
Thanks for having me.
Okay, that's all for today. Please follow the Masters of Privacy channel on LinkedIn if you want to find some interview transcripts, cheat sheets, and other useful resources and surprises every now and then. On top of that, episode notes and other feeds are available on mastersofprivacy.com. Thank you for listening.